Hello, everybody, and welcome to Law Bite number 308, dated September 11th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you so much for tuning in. This Law Bite is entitled, Appointing Maryland's Chief Judge. Before I begin, however, I'd like to invite you to subscribe to my YouTube channel, Juarez Lee Shelton MA, as well as click on that little notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new, exciting, and enlightening videos in history, law, political science, theology, and philosophy. Thanks so much in advance. You are the best. So again, this video is entitled, Appointing Maryland's Chief Judge. Maybe you knew, maybe you don't know, that Maryland, along with New York, are the only states that refer to the members of their highest courts, respectively, as judges and not justices, as it is normally done, both in virtually all the other states and on the federal level, of course. Additionally, along with New York, Maryland refers to its highest court as the Court of Appeals. Again, that is only replicated in one other place, New York. All right. All the other states refer to their state Supreme Courts as the Supreme Court of, or the Supreme Judicial Court, or the Supreme Court of Appeals, okay, in West Virginia, all right? Supreme Judicial Court is Maine and Massachusetts. Supreme Court of Appeals is West Virginia, and everybody else refers to it as the Supreme Court, as well as the federal level, of course. But this video is not a civics lesson about state Supreme Courts. I can certainly do that. But this video focuses on a unique feature of Maryland's Court of Appeals with respect to its chief judge. All right, the chief judge of the Court of Appeals of Maryland is, of course, the highest judicial officer in the state of Maryland and is the constitutional head of the Maryland judicial system. I guess I didn't need to tell you that, but for those who weren't aware, now you know. Okay? So the Court of Appeals is a very old judicial body, all right, dating back to the colonial period in Maryland, all right? And we're going to go real quick to the Maryland Constitution, all right? I know you don't have a copy of this in front of you, so I'll gladly read it to you. So we dance all the way to section 14 of the Maryland Constitution, which is a part, all right, of Article 4. Article 4, Section 14. Please forgive me for not saying that in that order, all right? Article 4, Section 14 of the Maryland Constitution outlines the structure, composition, and particulars of the Courts of Appeal. Specifically, we're referring to the Court of Appeals, our state's highest court. All right. And the feature that I'm highlighting, the whole reason I'm making this video for you, is because of this unique fact. Drum roll, please. It reads, one of the judges of the Court of Appeals shall be designated by the governor as the chief judge. Okay. So you're probably thinking, well, okay, Walter, get on with it. What's so special about that? Well, what's so special about that is it is replicated nowhere else in America. The governor of Maryland, based on this provision of Article 4, Section 14 of the Maryland Constitution, the governor of Maryland must appoint an incumbent member of the Court of Appeals to be its chief judge. Okay? The governor has to appoint one of the current judges on the Court of Appeals. There are 7 of them, by the way. to that position. The governor may not look outside of the Court of Appeals for its chief judge. It must be an in-house appointment. So you're still looking at me like, okay, what's so crazy about that, Walter? Well, it's unique and it is a bit strange that the Constitution of Maryland, as drafted by its framers, required this. And it is a unique feature, like I said, because no other state mandates. In the states, by the way, where the governor is responsible for designating the chief judge or chief justice of the state's highest court, nowhere else is the governor mandated by law or the Constitution to appoint someone currently serving on the state's highest court to be its chief judge or justice. Now, governors in those states certainly have the power to do that, typically, if they want to, but it's not mandated. The governor may elevate an incumbent judge, let's say, to that position because they like the individual, they respect their judicial philosophy or whatnot, whatever. That's the governor's choice. But nowhere in Maryland is it required, ladies and gentlemen, that the governor choose an incumbent judge of the Court of Appeals to serve as its chief judge. All right? The individual who sits in the center chair on the Court of Appeals, and again, is the constitutional head of the Maryland judicial system. It's more than just an inflated title. It's a lot more work from being an associate judge of the Court of Appeals. Okay? So, I say all this, ladies and gentlemen, because I wanted to share why I think that may not necessarily be a wonderful thing. Okay? And, you may or may not agree with me, but it's not like, with all due respect, it can be changed overnight. You would need an amendment to the Maryland Constitution, and I'm very thankful that, unlike most states, Maryland's Constitution can be amended very easily, very, very. Every time we go to the polls, if you're a fellow Marylander, by the way, we see a proposed constitutional amendment on the ballot, don't we? Yep, that's pretty much how it is. And that's pretty much, one of the wisest things I think we see with the Maryland State Constitution, the relative ease in the amendment process. Okay, so these are my particular, reasons for taking issue with this requirement. Okay, so like everything, there are pros and cons. Okay. The only real pro of this that I can see in all truth is that, you will obviously be getting someone as the chief judge who is intimately familiar with the work of the court and its dynamics. And by that, I mean its personalities. If you ever did a group project in school, everybody's different. Everybody has different tastes that have to be satisfied before you can get a uniform project. And it's pretty much the same way in working on an appellate court, or going out to dinner with 10 people. All right. Everybody has to be pleased before you can get harmony here. All right. So appointing someone who's already there, they're familiar with all of that, rather than appointing someone from the outside that doesn't know a hill of beans about any of the dynamics of the court. They might be familiar with appellate judicial work, sure, but when it comes to bringing all these personalities together, as its chief judge, you are the leader of the court, might not be so easy if you aren't familiar with these personalities. You're going to have to grow on the job, okay? But aside from that, these are the cons, right? The provision assumes that at least one incumbent member of the Court of Appeals, at least one, or the Constitution rather assumes that all of them, are fully qualified to lead the court And while, of course, they're legally qualified and professionally qualified, they just might not be otherwise qualified. Certain people are very hard-headed and are not very good leaders. Others are too soft and let the tail wag the dog. And that's definitely not a good leader, because as the leader, you've got to be somewhat authoritative. I didn't say you had to be a dictator, but you certainly do have to put your foot down from time to time as a leader. That's what makes you a leader. If you let others lead in your place, then you're just a leader in name only. You've got the subordinates telling the boss what to do. That doesn't make a good leader either. So that provision of the Constitution assumes that all the rest of these judges are free from all those negative traits and are ready to step up to the mantle as the leader. You know as well as I do, that might not necessarily be the case. All right. So the next con is that it reduces the ability of the governor to appoint a person who is perhaps more to his or her liking, more suited to the governor's own ideology to head the court, or even more qualified, which goes back to the first reason. All right, the governor should have a little bit more latitude, in my humble opinion, to appoint someone to head our state's highest court who they truly want. All right, the governor might not like any of the incumbents, and truth be told, might not want to appoint any of them to be the chief judge. But the Constitution of Maryland says, that's not my problem. You're going to appoint one of these people to be the chief judge, and that's all there is to it. Now get on with it. So, it reduces the ability of the governor to name someone who may be more suitable to him. And I only say him because we haven't yet got a female governor yet here in Maryland as of the time of this video. Okay? So the third reason is that it assumes that at least one of the incumbents, all right, wants the job. All right? The Constitution here in Maryland requiring the governor to elevate one of the current judges of the Court of Appeals as the chief judge, which is, a separate, is a separate judicial officer, a separate office, the head judicial officer of the state, okay, the constitutional head of the Maryland judicial system, assumes that at least one of these other judges wants that job. That might not necessarily be the case, all right? Being the chief judge, ladies and gentlemen, is not just an inflated title and more pay. There's a reason that it's more pay. It's because it's more work. Indeed, not only are you the administrator of the state's highest court, the Court of Appeals, and your 6 other colleagues and the administration of that body overall, but guess what? You are the constitutional administrator of the entire state judicial system. You provide oversight for the entire Maryland judiciary. Of course, you have subordinates in the form of district administrative judges and circuit administrative judges who provide the necessary follow-up to you when things need reform in their respective judicial districts or circuits. But ultimately, the oversight power is yours, all right? You must make a lot of decisions. And of course, you oversee, as the chief judge of the Court of Appeals, you oversee bar admissions and other things related to the regulation of the practice of law in Maryland. So you see, bigger title, more work. A lot of people always say, well, you get that nice, pretty title. Yeah, but you also get nice, pretty work with it, okay? All that glitters is not gold, folks. And all that's gold does not glitter. So even if certain people are on power trips and just want that title, it's more work. Others know a good thing when they have it. Being an associate judge, far less work, far less BS in politics to deal with. The chief judge, oh my gosh, sorry, but you're not included in that scenario. It is definitely a bunch of politics and red tape for you because you are the chief judge and you are the head of the state's judicial system. Give yourself a pat on the back and a clap, because you assume this great responsibility. So this other part of this constitutional provision assumes that any of the other judges on the Court of Appeals wants the job. Guess what? They might not want the job. They might be perfectly happy being an associate judge of the Court of Appeals. And there's nothing wrong with that, okay? Like I said, it's far less work, less BS, less red tape you have to deal with, okay? So those are my reasons why I take issue with that provision that the governor shall designate one of the judges of the Court of Appeals to be its chief judge. Most people would read the Constitution of Maryland, would glance over that and not give it a second thought. They're like, okay, so the governor has to pick one of the current judges to be the chief judge. Okay. But in doing so, these things I just mentioned come into play. You know, it assumes that all those other people are actually qualified to do it and would make good leaders. If you've got a court that's fractured, I don't think appointing an incumbent is the best idea. You know, reducing the ability of the governor to choose who they want might not be the best idea either, because typically the governor, with the help of the nominating commission, can make great choices. All right, so you know, you filter out people who should not be even considered, and you get a good one. And that good person can certainly come from outside the court. And of course, like I said, it's problematic because it's assuming that any of them already on the court would want to be its chief judge. Not everybody is on a power trip. Not everybody wants to lead. Not everybody is able to lead. Not everybody can be an effective leader, even if they are able to lead, okay? Desire to lead and ability to lead are two totally different things. And, you know, I don't think this constitutional provision here, this constitutional language, rather, in Article 4, Section 14 takes these things into account, which is why I would suggest an amendment to the state constitution that would allow the governor to designate an individual from outside of the Court of Appeals to be its chief judge, if they wish to do that. I don't feel the governor should be bound to nominate someone on the court to be its chief judge when not everybody on the court may be able to lead or want to lead, okay? The governor should have their freedom to do that, all right, as it is in all the other states where the governor designates the chief justice of a state Supreme Court, all right? For the record, at the time of this recording here in Maryland, our incumbent chief judge, Mary Ellen Barbera, just stepped down as the chief judge of the Court of Appeals. She was the very first woman to ever hold that role, all right? She served in that capacity as chief judge from 2013 until 2021. And to succeed her, Governor Larry Hogan appointed Judge Getty, all right? He too will have to retire in 2022. And then Governor Hogan will be able to make another chief judge appointment to the Court of Appeals. So, you know, in my lifetime, I have seen and have lived through, thus now, 4 chief judges of the Court of Appeals of Maryland. Chief Judge Robert C. Murphy, Chief Judge Robert Bell, Chief Judge Barbera, and now Chief Judge Getty, all right? And I'm not that old, but I've seen quite a bit, and I have been to the Court of Appeals building in Annapolis, and I have sat on the Court of Appeals bench, all right? Right in the center chair, all right? I did a video on that, by the way, if you want to look at it, sitting in the Chief Judge's chair, the Court of Appeals of Maryland. I was invited by then Chief Judge Robert Bell, all right? So that's my story, and I'm sticking to it. I just wish to share this very interesting piece of information as someone who has always been in love with the judiciary, both state and federal. I enjoy finding interesting constitutional provisions with respect to the judicial branch of government, and just thought I'd highlight this, and honestly would love to know what you think, all right, whether you're a Marylander or not. Okay, so if you have any questions or controversies, you can leave them down below. I'll be happy to answer them. If you like this video, gain some insight from it, drop me a like. That would be greatly appreciated. And last but not least, if you've not subscribed to my YouTube channel at this point, please do so now. Juarez Shelton, MA. All subscriptions matter, and I appreciate each and every one of you more than you will ever know. Take care. Stay safe out there. Thank you so much for listening, and I'll talk to you at the next video. Peace.